All right, let's jump straight in. For all you Judge-Elonian University law students tuning into this explainer for your IP course, grab your notepads because we're throwing you right into the deep end today. Imagine you're sitting in this highly polished, glass-walled office of a corporate management board. You know, it's a totally regular Tuesday, right until a massive stack of legal papers literally slams onto your desk. It's the kind of threat that could completely derail the company. We're talking about a full-blown corporate crisis.
And the absolute sheer scale of this crisis, it comes with a massive, eye-watering price tag attached. 1 million Polish zloty. Yeah, this isn't just some minor administrative error or, a quiet little HR dispute. This is a sudden, explosive lawsuit that hit the MEBLEX company completely out of nowhere on March 7th, 2021. And that 1 million zloty number, that's going to dictate absolutely everything we dissect today.
I mean, just listen to the absolute fury dripping from the official statement of claim. The plaintiff accuses MEBLEX of, quote, infringing personal rights and violating the provisions of the GDPR, seeking compensation to the tune of PLN 1 million, end quote. Guys, these are incredibly heavy accusations. And the kicker, they're coming from their very own financial director. So the absolutely crucial question here is, how on earth does a highly successful office furniture manufacturer find itself fighting a million zloty war against its own executive?
Well, to find out, we go to Section 1, the party at Forty Kleparz, where it all began.
To actually figure out how we got here, we need a flashback. We need to rewind the clock and trace exactly how a really fun company celebration completely mutated into a legal disaster. So, February 2020. MEBLEX throws this massive integration party at Forty Kleparz with LoftoDance, and it's a huge success. We are talking over 200 people, employees, spouses, family members, all partying hard into the small hours of the night. You've got a hired photographer weaving through the crowd, capturing all the action. But then, a full year passes. Nothing happens. Everything's completely quiet. Until March 2021, when this ticking time bomb finally explodes and lawsuits just slam into the management board's desk.
Now, everything we are breaking down today is grounded in official documentation, specifically your Project 1 case file from Barta and Kalinsky for your IP student course. So this isn't just some abstract theory. This is a simulated, high-stakes legal reality based on true facts. You need to treat this case exactly as if you are the external counsel brought in to literally save MEBLEX from ruin.
Okay, so here is the very first layer of copyright complexity we have to untangle. Our inciting incident actually involves that photographer. Consider this critical fact, right? The vaguely drafted vendor contract with the photographer completely lacked an explicit image distribution clause for internal or external marketing purposes. Under the Polish Act on Copyright and Related Rights, that omission? Yeah, that is essentially a loaded gun just waiting to go off.
Which brings us to Section 2. The intranet and the leak. The boundary is breached.
But the thing is, the photographer's contract is only the beginning of the nightmare. Enter a character we'll call the rogue marketer. This chain of custody beautifully illustrates how a fun night out devolved into a severe breach of protocol. Step 1. The photographer records the party. Normal enough. Step 2. Our rogue marketer decides entirely on their own to publish selected photos to the MEBLEX internal company blog. Step 3. Here's the massive structural flaw. MEBLEX actually shares an intranet with its subsidiary BestProjects. The boundary is officially breached. And then Step 4. The marketer finds some of these photos so hilarious they actively leak them via direct message to a colleague over at the subsidiary.
Now, legally speaking, we really have to separate the media in question here. On one side, we have your regular employee photos, group shots and individual pictures posted to the internal blog. But on the other side, we have highly targeted, incredibly embarrassing shots of the financial director, who, by the way, is explicitly noted as not being a popular figure at all, dancing on a table with his wife. These targeted shots were intentionally leaked to colleagues at BestProjects specifically to mock him. So as you can imagine, the legal protections surrounding these two distinct sets of photos are vastly, vastly different.
Let's move on to Section 3, Monkey Heads on YCAP, Public Distribution.
And this brings us to the dramatic climax. This is where catastrophically poor judgment collides head-on with the power of public distribution. Because the colleagues over at BestProjects, they didn't just laugh in a private chat. No, they took those leaked photos of the financial director and his wife and plastered them all over the public Polish website WikiUp, attaching this highly mocking meme quote, "This is how the elite parties." They literally weaponized the image of an executive for public internet entertainment.
Okay, let's rapid-fire this unbelievable cascade of disastrous decisions. First, obviously, publishing to a public forum. Huge mistake. Second, trying to hide the director's identity by literally morphing his and his wife's faces into monkey heads. I mean, you can't make this stuff up. Third, they actually did this based on the overconfident assurance of an IT specialist who promised them over the phone that this flimsy disguise made them completely unrecognizable. And fourth, oh, here is a really spicy complexity to test your legal analysis. That IT specialist wasn't even a full-time employee. He was an external contractor. Suddenly, the liability web just got a whole lot messier.
Which leads us to Section 4, the corporate legal fallout, a two-front war.
So let's snap back to the present day. The laughter has completely stopped, the monkey heads are gone, and we are looking at this intense two-front war that is paralyzing the MEBLEX board. Threat number 1. 3 regular employees have sent formal letters before action. They are furious about the group and individual photos on the internal blob. They are alleging they gave zero consent to be photographed or distributed, and they are demanding to know why they weren't paid. Then there's threat number 2, the absolute nuclear option, the financial director's official statement of claim over the morphed meme photos. He is alleging severe violations of personal rights and GDPR, and, as we know, he wants his 1 million zloty.
All right, let's get our definitions completely straight for your analysis. Personal rights, or personal interests under Polish civil law, represent the legal protections for an individual's honor, reputation, and specifically, their image, against unauthorized infringement. Gluing monkey heads onto an executive and his spouse and posting it on a massive forum like Vikop, that is practically a textbook case study in reputational damage. But the real question is the company fully liable for the actions of a rogue subsidiary employee?
And then, of course, we have the GDPR violation. Remember, a photograph is personal data if the person is identifiable. The unauthorized processing, internal posting, leaking, and external distribution of these recognizable images trigger strict European data protection regulations. So the board isn't just fighting a civil suit here. They are fighting a massive, multi-layered data privacy puzzle.
Finally, Section 5, your turn to advise. We are handing over the gavel to you. Right. I am officially taking off the explainer hat and putting on the persona of a very demanding senior partner at your law firm. Shagi Yalialan Law Students. MEBLEX is bleeding, and they are looking to you for a lifeline. First thing I need from you, identify the precise statutory violations in fact. Did MEBLEX even have the right to photograph the event? Under the Polish Act on Copyright and Related Rights, is implied consent, simply showing up to the party, actually sufficient to distribute someone's image on a company-wide intranet? What about third-party image distribution? You need to tell me exactly what laws were broken.
Next, I need you to untangle this ridiculously messy web of vicarious liability. Who should actually be sued? Does the financial director go after MEBLEX, the subsidiary BestProjects, the marketer who leaked the photo, the colleagues who posted it on Vikop, or maybe the external IT contractor who gave the terrible advice? And conversely, who exactly has the legal standing to sue the management board itself?
I want you to really weigh the legal risks here. Look at the board, look at the rogue marketer, look at the Vikop posters. When the dust finally settles on this, and that million zloty is either paid out or dismissed, who is the ultimate fall guy in this corporate thriller? Who should fear the legal consequences the absolute most? I want a name, and I want a rock-solid legal justification.
So here is your final task for this explainer. You need to synthesize everything. The vaguely drafted photographer contract, the cross-company intranet leak, the Vikop monkey heads, the whole debate over implied versus explicit consent, and of course that 1 million zloty demand. Draft your email to the management board. Recommend your concrete course of action. Will MEBLEX actually prevail if these claims go to court, or do they desperately need to settle? The clock is ticking, counsel. What's your move?